All right, welcome to our channel. Today, I'd like to discuss, can you have a live-in aid while you're on Section 8 and utilizing Housing Choice Voucher? And we're also going to talk about all the other Q&A for this, including other program requirements, federal requirements, and PHA requirements for it, depending on what your circumstance is. So before I get started, my name is Jay. I am the owner of Section8Consulting.com, and today I want to present some information about our company as well. If you find yourself in a situation where you're not certain about your circumstances, or you have a contentious issue with your landlord or the housing authority, you may want to reach out to our office. The phone number is up top here, along with the web address, as well as email. We offer appointments. They're not free, but they're very affordable. That being said, let's move on here. I'm going to bring in some notes for you guys, and I'm going to move my face off to the right here. That way we can talk a little bit more, and I'm going to bring in notes because I realize some have learning disabilities, and also many may have struggled to follow at the pace in which I speak. So this will allow you an opportunity to be able to digest the information a little later. So moving on from this, yes, a person receiving a Section 8 voucher may have a live-in aid when aid is necessary for an elderly or near elderly or disabled household member. The housing authority must approve a qualified live-in aid or disabled member. Approved live-in aid is necessary as a reasonable accommodation. And many of you guys need to understand, reasonable accommodation is a very serious matter in which you have to file with the PHA. Attempting to file a boilerplate accommodation requests, or just handwritten ones, or AIing this is not going to be sufficient to get approved, because there are several steps inside that letter, including proving nexus, that are often fail for most people when attempting to do so. So you're going to need a good understanding of federal rules. Otherwise, most PHAs are designed a lot like insurance companies. They will deny, deny, deny. Moving on from there, however, the tenant cannot simply allow another person to move in late or identify that person as an aid. Approval should be obtained from the public housing authority nearest you, and that begins with the assisted living unit that you're currently renting. What qualifies as someone as living aid? Under HUD's definition, living aid is a person who is the following: is essential to the care and well-being of an elderly person or near elderly, as well as disabled, is not legally obligated to support that person, and would not otherwise live in the assisted unit except to provide necessary support services. It should be important to note that this can be a contentious topic, because some live-in aids may be there longer than others. Some may just be resting there, depending on shifts and timing. So it depends on the type of live-in aid. Live-in aid must assist with the needs as such: bathing, dressing, grooming, toileting, preparing meals, medication, reminders, monitoring, mobility, transferring, fall prevention, overnight supervision, responding to medical emergencies, assistance related to physical, developmental, psychiatric, or cognitive disabilities, or other disability-related activities. So this is very clearly written through federal rules. So you're, having a live-in aid needs to be connected to this. You need to be able to prove that nexus. The tenant does not necessarily need a continuous hands-on assistance every hour of the day. The medical provider should explain why the aid needs to reside in the home rather than simply visit periodically. That's where also this will become very contentious, is because many of you simply do not know how to write the requests to differentiate the two of those, where it would meet actual federal procedures or the administrative plan issued by the PHA. Who can request a live-in aid? Well, HUD's regulation allows a family member consisting of one or more elderly or non-elderly or disabled persons to request an approval of a live-in aid. For this purpose, the elderly generally means 62 years and older. Near elderly means 50 to 61. A person with disability may have physical, mental, emotional, cognitive, or developmental impairment meeting the applicable program or fair housing definition. Essential to the question is whether an aid is necessary to provide supportive service, not merely whether having a person in the home would be helpful or convenient. And I think that, they kind of define that in Title 24 CFR 982.316. And you'll be able to find this linkage in the description, as well as a comment later, and you can digest that information as you will. Does the person have to be a nurse? No, a live-in aid does not ordinarily have to be a nurse, certified nursing assistant, employed by a home health agency, paid for provided care, or unrelated to the tenant. We ran into a circumstance just recently where the housing, not the housing authority, but the landlord actually sent a very demanding letter suggesting that somehow the client, which was a relative, of each other living together as a living aid, that they needed to be somehow a licensed nurse. And so our office had to step in and set that record straight through formal demand to that property to let them know that we're keenly aware of their deception in the way that they did that letter. The hope in the end from the landlord was that the client did not understand how to exercise their rights and therefore would have taken that letter very seriously. Moving on, can a relative serve as a live-in aid? Potentially, yes. A relative, including an adult child, sibling, parent, or other family member, may qualify if the person satisfies HUD live-in aid definition. The relative must establish that they are essential to the person's care. They are not legally obligated to support the person, and they would not be living in the home except to provide the required supportive services. Keep in mind there are both live-in and non-live-in, and there are caring for a person for a few hours for a ship, and then of course being there overnight. So those all require different definitions. A spouse ordinarily cannot qualify because the spouse generally has an obligation to support one another. State law, in particular household relationships, can affect this question depending on your state as well. So you're not just dabbling in federal rules, you're also dabbling in whether or not there are state rules. And furthermore, this can be further complicated by the way the person, if there's an extra room required for this, and state law, like in California, where they may consider a living room to be a general living space. So you see, there's many layers and complexities to this. So what documentation can the housing authority request along with the landlord? Well, when the disability is or need is not obvious, the housing authority may request a reliable verification by an appropriate third party, such as a licensed physician, a psychiatrist, psychologist, licensed therapist, a social worker, a nurse practitioner, or other qualified medical service provider familiar with the person's limitations. And, when we speak on other, there are a lot of other options there on there, but each one of these, as you get lower in the list, are going to be harder and harder to prove. Okay. A useful verification should explain that the person has a disability, the functional limitation or care needs related to the disability, why eliminated would be necessary, why the visiting, intermittent, or daytime assistance would not adequately address the need, whether the overnight assistance, supervision, or emergency response is required, and of course, the expected duration of the need, which could be temporary for a longer duration or permanently. The provider normally does not need to disclose every medical record to provide extensive medical history. You're protected under HIPAA law, but you still have to meet the merits of federal law in order to prove this. The letter should establish the disability-related connection between a person's limitation and the request of accommodation. And so we move on to, must the housing authority also approve that aid? Of course, because they are naturally the people that approve the voucher, therefore they have a say in this. And so yes, the approval for the need of an aid is the approval for a particular person may be treated as a separate decisions, okay? HUD's guidance says the family must identify the proposed aid before the housing authority grants final approval. The housing authority generally cannot issue a larger voucher for an unidentified person who may become an aid and sometimes in the future. So we're going to take a look at PHI Notice 2014-25. The housing authority may reject or withdraw approval for a particular person if that person has these particular set of problems. They committed fraud, bribery, other corruption, or criminal act connected with a federal housing program, committed drug-related or violent criminal activity, currently owes rent, money to the housing authority in connection with Section 8 or public housing. And let me tell you, this only clears the bar for the PHA. There's even more extensive policy in terms of the lease and the landlord. Just because the PHA agrees that person to be there does not mean that the owner of the property has to agree to any further activity outside of this. So rejecting one proposed person does not automatically establish that the disabled tenant has no need for live-in aid. The tenant may be able to propose another qualified person. And so we go on, does the aid income count? Generally, no, as they are separated. However, an approved live-in aid is a household member, but not a member of an assisted family. That means that the aid's income is ordinarily excluded when the housing authority calculates the assisted family's annual income and tenant rent, and they're speaking directly to the payment or cost for the voucher. And this exclusion is important because an aide may work elsewhere, receive retirement income, or receive disability benefits without automatically increasing the voucher holder's rent. HUD's HOTMA guidance identifies income received as a live-in aid as excluded from the family's annual income calculation, and you can view calculation terminology under HUD's Notice PIH 2023-27. I've linked that up as well. Take a quick sip of water here. You can receive an additional bedroom, usually if an approved live-in aid or can support the additional room in a family's voucher size. HUD's guidance generally allows one bedroom for a live-in aid. However, for example, a disabled tenant who otherwise qualifies for a one-bedroom voucher may qualify for a two-bedroom voucher when approved as a live-in aid is necessary. So in this particular part, I'm not going to get too deep in that because that brings up a whole set of different rules when you get into additional rooms and you mix that with the conversation of live-in aids, okay? What I am going to do is I'm going to put the subject matter in the comment section and description, and will also be covered under that. It's going to be what about rotating or occasional caregivers? Can an aide bring a spouse or a child? Does the aide have rights to the voucher? Can the landlord screen an aide? How to request a live-in aid? Sample request language for the letter, and if the request is denied, obviously what to do. And then I'm going to bring up HUD's Fair Housing and Non-Discrimination Guide, and then, of course, give you my closeout and closing notes, which would be the bottom line for anybody's case. So as you can see, there's plenty there. Well, look, guys, I've enjoyed talking with you. I'm sorry it's a little bit a lot to take in, but, you know, in the reality of it is, a lot of clients, before they come to my office, go out there and they attempt this on the basis of the wisdom of Google search or even an AI. And I got to tell you, you know, even when my office uses AI, it's with a limitation of having a program roughly 5 to 10 pages of instruction into it. So just be very careful of that, because a lot of these arguments cannot be rehashed with the housing authority. They're not. If they deny you, then you could have killed your singular opportunity to make this work, and others are simply using outdated or irrelevant information. So be careful how you take your advice. I've enjoyed talking with you guys today. We do live videos on Tuesdays, Thursdays, and Sundays at 10 a.m. Central Standard Time. And if you'd like to join us and ask questions there, go for it. If not, we make two EDU videos, educational videos per day, except for the days we do lives. And you can join us then as we talk about a lot of the subject matter for Section 8 and so on. I've enjoyed talking with you, and have a great week. Bye for now.